Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA-CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Thank you.
Hello, Dr. Suzanne Bechtel here again with another lecture concerning contracts. And in this lecture, we're going to talk about legality and capacity in contract law. And these are very essential factors to having an enforceable agreement. Here we're going to talk about the legality of subject matter and the contractual capacity requirements for having a valid contract. So far we've talked about offer, acceptance, and consideration. Three main things you have to form a legal contract. But we have three other requirements we'll talk about as well. We'll cover two of them, legality and then capacity, to contract here in this lecture. And in another lecture coming up, we will cover contractual content. So first of all, with legality of subject matter, it probably doesn't surprise you that contracts for an illegal purpose are not valid. So contracts to do something that's against the law, like stealing or hurting someone, committing some crime, even if you haven't written down, and everybody has signed it, you can take that to court to enforce if somebody doesn't fulfill their obligations under it. So that's, the main thing. So we'll begin with a short review of the key components we've covered so far: offer, acceptance, and consideration. And then we'll look at the additional requirements for a valid contract, including legality, capacity, and mutual assent, which is the meeting of the minds, which was covered actually in a separate lecture already. So in review, the first three principles of a valid contract are offer, acceptance, and consideration. The offer must be a clear proposal made by one party to another for the purpose of forming a contract. Acceptance is the unqualified agreement to the terms of the offer by the other party. Consideration refers to something of value exchanged between the parties to make the contract binding. Some additional requirements. First, the last one on the list here has already been covered in a separate lecture, and that's contractual intent or meeting of the minds. And again, we have to have all three of the previous, and these are also requirements. So we're going to cover the first two here in this lecture on legality and capacity to contract. So as I've already discussed, legality, it's no surprise that contract to do something like steal or hurt someone, the committing of some crime, even if you've written it down and everybody signed it, you can't take that to court to enforce it if somebody doesn't fulfill their end of the bargain. So that's the main thing, obviously. The next to the last requirement is contractual capacity. And here our concern is simply that if someone is going to be held to a contract, they have to have the mental capacity to truly understand that they're entering into a contract and what that entails. As we've noted already, a previous lecture covers contractual intent. The legality of subject matter we're going to cover the invalidity of contracts for illegal purposes, what types of illegality there are, malum in se and malum prohibitum, and then look to quasi-contractual relief in cases of malum prohibitum. The general rules in the category of legality of contracts are that contracts must be for legal purpose to be considered valid and enforceable by law. Also, contracts established for illegal purposes are deemed invalid and carry no effect. We look at types of illegality because it does make a difference in the exceptions that always seem to have in the law. So first of all, we have to look at we have two types of illegality. We have malum in se and malum prohibitum. So these are lovely Latin phrases. Malum in se simply means wrong in and of itself. It's just a bad act, like hurting someone, killing someone, stealing that type of thing. Things that are generally considered to be morally reprehensible and wrong. And those types of things are never going to be something that would form the basis of a legal contract. So if the contract is for stealing something or harming someone, or it's the court's never going to enforce that. The other type of illegality is called malum prohibitum. And these are things that we have made illegal with our laws, but they're not really ones that necessarily are wrong in and of themselves. It's just something that as a society we prohibited, and we've done that through promulgation of law. We've deemed these acts to be illegal and as being against public policy. So in this area of malum prohibitum, 3 examples are provided: usury and gambling and licensing statutes. Usury simply has to do with the rate of interest that you're charging. When you have a credit card, they charge you interest when money is loaned to someone. So if you've taken out a loan, you're probably paying it back, plus some extra money called the interest. And that's how the lender makes money. So banks make money in that way. But usury refers to a contract that charges or includes in it a term for interest that is greater than it is allowed by law. So interest rates above the amount defined by the legislature is prohibited. The maximum interest rate is going to vary from state to state. Gambling is another example. Some people don't think there's anything wrong with gambling, and some people do. But it varies again from state to state in terms of what kind of gambling you can have. You have Nevada, where you have casinos and all types of gambling, and all of it's legal. And then you have other states where you can't have that extent of gambling. Perhaps only a slot machine form of gambling is permitted in some states. So if you have a contract that involves a gambling aspect to it, let's say 2 people that bet on things and they don't pay, if it's legal in that state, then it can be a contract. It can be the basis of a contract. But if it's illegal, it's not going to be enforced. Licensing statutes are another example of malum prohibitum, prohibited acts. What we mean by this is we're talking about professions or people that have to be, or businesses that have to be licensed under the state or state law. And that state law will say something such as, to be a contractor, you have to be licensed to practice, to do that work in the state they're in. You have to be licensed and things like that. So if it's a contract, say a contractor to do some work in your house, and it turns out they're not actually licensed as you thought they were, if they're not actually licensed and the state requires contractors to be licensed, then the contract would not be a legal one, and so it would not be enforceable. These malum prohibitum contracts, such as the ones that fall under usury, gambling, and whatnot, generally these will not be enforceable because they're not considered to be legal contracts. However, because these are public policy type issues, the court may decide to grant some bit of relief to the party if they can show some sort of unjust enrichment. What we mean by that is if you can show that the other side was unfairly or unjustly enriched by what you did because you thought you had a contract, even though it turns out you didn't have one. So let's say we have a contract and it's for a rate of interest that's higher than the amount allowed by law. But every other part of the contract is just fine, and the parties did what they were supposed to do. For example, loan the money or what have you. The court might enforce it, but only up to the legal amounts of interest. So now let's talk again about malum prohibitum, because these contracts that fall under usury, gambling, licensing, and whatnot, these will not be enforceable because they're not considered legal contracts. However, because they are public policy type issues, the court may decide to grant some bit of relief to the party if they can show unjust enrichment, even though it turns out you didn't have one. So let's say you have a contract and it's for the rate of interest that's higher than the amount allowed by law. But every other part of the contract was fine and the parties did what they were supposed to do, loan the money or what have you. The court might enforce it, but only up to the legal amount of interest. Next, we turn to the statute of frauds and the requirement of written form of contract. You can also call the written form contract a formal contract, as opposed to an informal, lack of a better description, handshake. So we'll talk about these in areas of real property, sale of goods, and those in time-based situations. So the fourth type that falls into the malum prohibitum is called the statute of frauds. And this is something important for you to understand. The statute of frauds originated back in England during feudal times when you had judges that traveled the country and heard cases. And, they were creating law back then. If you can kind of remember from your history, the big thing back then was land and land ownership. And also people didn't live very long. Like, the average lifespan was much shorter than today. So there was always the concern about things like, testimony or people being able to prove the existence and the terms of a contract over a course of time. And so over time, as these traveling judges heard cases, they developed common law in the area of contract, and they developed 5 types of contract that they said must be in writing to be valid. So if these types of contracts are not in writing, they're not enforceable. They're not a legal contract. And the statute of frauds was incorporated into our law in the United States, and it's still the law today and includes the areas I'm going to cover next. A contract for the sale or an interest in real property. It's a biggie. Any contract having to do with real property, and that's land and things affixed to land, is real property. So if you're buying a house, if you're renting an apartment or a condominium or renting a house, if you're buying land, anything having to do with real property, there must be a contract in writing. You might ask yourself questions like, if we have rented an apartment from a friend of yours for, some period of time and we never put it in writing, and there wasn't a problem. Okay, well, if everyone does what they agreed to, if you paid the rent and there were no problems in terms of that, then it's never an issue. The issue would come if you didn't pay the rent or the person didn't provide access to the land as they promised. Then you went to court and try to enforce it. The court's going to say, I'm sorry, but your contract should have been in writing. And if it wasn't in writing, it's not a legal contract. It's not enforceable. The same goes for sale of goods when they're over $500. These need to be in writing, and a contract that cannot be, and also a contract that cannot be performed in 1 year. So that means that if you look at the terms of the contract, and let's say it's to provide cleaning services for an office building for 5 years, that obviously can't be performed within 1 year. So that would need to be in writing in order to be valid. A contract in consideration of marriage is also required to be in writing. What we mean by this is a prenuptial agreement and other types of agreements. A prenuptial agreement is an agreement to allow that would allow as to how things would be divvied up and whatnot if a married couple got divorced. These are made before the marriage, and sometimes people already married will make an agreement to enforce obligations or non-obligations if the couple divorces, and these are called anti-nuptial agreements. They resemble the same thing that the couples married already entered into, like the prenuptial for the folks that were unmarried yet, were getting married, the prenuptial agreement. But as to antenuptial agreements that are made after a marriage, I just like to say, if your spouse asks you if you're already married and they come to you and say, hey, let's come up with an arrangement for if we happen to get divorced, how we're going to divide up our property, I think that's a big red flag. We've got some problems here. But in any event, in consideration, a contract that has to do with marriage needs to be in writing, and this is the history from back in the days. Like I said, these were from the old days in England, where most of the time families were trying to marry off their daughters. And as part of that, they would offer what's called a dowry. And that means that to encourage somebody to marry, or somebody that already wanted to marry their daughter, to marry the daughter, they would say, along with my daughter, you get this land, or you get a herd of cattle, or you're going to get a certain amount of money. And that amount of money, any of that would be called a dowry. So if there was a dowry, and that's how it got started. But now it includes prenuptial and postnuptial and all those things in writing. The last one is a promise to pay the debt of another person. So if you agree to pay somebody else's debt, that has to be in writing. And I think if you take a look at these as a whole, you'll see why the courts probably decided, these types of things. I mean, land is a big deal, saying you're going to pay someone else's debt, plan for dissolution of marriage, etc. If that was an issue later in terms of having it in writing, we could look back. The court really wants to see in writing the terms of this contract. That's it. And that's as opposed to having to that's one of the keys is it circumvents the need for testimony of the parties to the contract and maybe witnesses who are going to tell the court, yeah, here's what happened. And if you're at the point where there's an alleged breach of contract, you're in litigation, and people might have some motivations to maybe not be entirely truthful. And then the other part of that is maybe they just don't remember. And of course, back in the days when this was going on, or this began, they might not be around, and they might have passed away because the life expectancies were much lower. So this is one that, these are the reasons behind making these type of contracts be in writing. But real quick, circling back again to malum prohibitum, recognize that the statute of frauds is legislation that fits into this category of crime, malum prohibitum. And so exceptions are available based on equitable relief for a scenario involving, for example, interest in real property and other types of contracts we've already covered in this lecture. And an example in a real estate scenario, even if it wasn't in writing, if the parties can show someone has been living on your property all this time and they didn't pay you rent, and you're suing them for rent, and technically there's no written contract, so it wouldn't be enforceable. But that's not fair to the landowner, because this person's been on their property. They should at least have to pay for the time they've been on it. Something like that, where the court would be looking to enforce it or come up with something that makes sense and is fair and equitable under the law. And generally, even though these will not be enforceable because they're not considered to be legal contracts, because these are public policy type issues, the court may decide to grant some bit of relief to the party if they can show some sort of unjust enrichment. So lastly, in this lecture, I believe this is the last section, it's on contractual capacity. And basically we're talking about the legal ability to enter into contracts and what are the requirements and exceptions for minors, minor children that is, people under the age of majority, which in most states is 18, but in some it's 17. Mental capacities also comes into play here, and how things like substances, alcohol and drugs, and other properties of people's minds might come into play in contracts. So this is the next to the last requirement in contractual capacity. And our concern is simply that if someone is going to be held to a contract and they have the mental capacity to truly understand that they are entering into a contract, what does that entail? So the three areas that we look at here where the concerns are age, mental capacity, and in situations where alcohol and drugs are involved. These are the most common capacity issues. The bottom line is you have to be legally an adult, which is usually 18. And there's some different ages in different states. But usually you have to be an adult to enter into a contract, and minors simply can't enter into contracts. So this is why you see parents and other older people over the adult people signing leases and things like that for their children who are minors. But once a minor attains the age of majority, once the 18, let's say, is the age of majority in the state where they live, they can decide they want to go through with a contract. So that's why it falls under this category of voidable. And you'll remember earlier on in this course, we talked to you about void and voidable. And voidable meaning one of the parties can choose to violate the contract or affirm it. So if you have a 17-year-old and a 19-year-old who enter into a contract, the 17-year-old can choose to have it voided because they're minor. The 19-year-old who entered in the contract at 19 has to abide by it. And in the other case where the 17-year-old entered into the contract, they can disaffirm the contract when they turn the legal age of majority, but they need to do that immediately after turning the legal age of emancipation in the state where the minor lives. And there are some exceptions, though, that we're going to cover for a second here on necessaries. So minors can, and again, by minors, I mean usually the ages 14 to 17 where this might come up. The court's going to look at it, but a contract for necessaries like food, clothing, shelter, and medical care would normally be enforceable. Sometimes contracts for education or maybe marriage contract is also enforceable on a minor. A big one people ask about is an enlistment contract. Somebody signs that enlistment contract when they're 17 and they turn 18 and say they want to get out of it. That's one of the exceptions. You will be held to that contract. So if you sign a military enlistment contract, you'll be held to it. All right, mental capacity, and this is the last part here, and we're talking about someone who, because of either a mental deficiency, like maybe Alzheimer's or mental retardation, or some brain damage situation, doesn't really have the capacity to understand about entering into a contract. The same is true of people on drugs, and so we look at that always on a case-by-case basis. So no need to go into a lot of detail here, but these are, a mentally deficient person lacks capacity to enter into contracts. A person under alcohol or drugs may not be able to form the contractual intent, which is meeting of the minds. And that's something, again, courts take on a case-by-case basis. So to include, it's important to know that a contract must be for a lawful subject matter. Statute of frauds is essential to understand that some contracts are formal and must be in writing by law. And the parties to the contract must have the mental capacity to contract. And what we're doing in the long run is ensuring enforceable agreements. Thank you.
I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also, there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.